If I get behind on my payments, can they sue me? Will I go to jail? Ted is here. Let's begin.
This is Debt Free in 30. Here's your host, Doug Hoyes.
Okay, Ted. You do not know what the topic is because you don't get any cue cards for this one. The topic is legal action creditors can take when you don't pay.
Got it.
So my first question for you is, how common is it for someone to call our Hoyes Michalos 310 plan debt helpline? They get you on the phone and they tell you, I'm behind on my payments and one of their credit cards or loans or somebody is threatening to sue me. How often does that happen?
Just about every hour.
Every single time. So if you don't pay your credit card, can they actually sue you, or is that just an idle threat, a collection tactic?
Well, so the reality is they have that right. So anyone who's involved in some kind of contractual relationship with someone, if one of the parties doesn't uphold a contract, the other party has the right to sue.
And we're going to talk about that.
Yep.
Okay, so the other part of it is, will you go to jail?
No, you don't go to jail in Canada for not paying your bills.
And do collectors use that as a threat all the time?
Well, collectors certainly use the lawsuit and the legal action as a threat, and they imply that bad things are going to happen to you. I don't know if any of them actually say they're going to send you to jail. But they might use that on the new Canadians more than they use it on anyone else, because in their old countries, you do go to jail.
That's exactly what happens. Exactly right. So, okay, so this is an important show because every single day for the last 26 and a half years that you and I have been running Hoyes Michalos and Associates, because we started it when we were 10.
That's right.
We get calls from people who tell us the story about that collection agent who's threatening to call their employer, sue them, garnish their wages, seize their assets, send them to jail.
Right. Some
of these are real threats. Some of them are not. So we're going to break it down, separate the fact from the fiction.
Okay.
So we're going to start with an obvious scenario. And again, you're just hearing this stuff for the first time. So we'll see if you understand how to do all this kind of stuff. So our listener or viewer on the big YouTube there, they were doing fine and they lost their job or got sick or got divorced. Pretty common story so far, right?
Any one of those works.
They got behind on their payments on their credit card. Maybe it's Canadian Tire, which is called Triangle now.
Man, they don't sponsor us, right?
They do not. None of these people are
They're
sponsors.
not going to now.
Neither does Capital One or the bank or anybody else. So it doesn't really matter who it is.
Yep.
So I want you to talk us through the collection process. So I've always paid on time, and I just missed my first payment.
Okay. So usually you miss your first payment. All you're going to get is a polite reminder that, hey, you missed your payment last month. Is there anything we can help you with?
So no big deal.
Shouldn't be.
No big deal. Okay, so what happens now when I've missed my second payment?
You miss the second payment, and there'll be a less polite reminder. The language is certainly different. It's a little bit more aggressive. You might even get a phone call the second month you missed. If we're talking about this is the first time you've got a history of missing things. We're going to change the scenario to folks that miss payments all the time. That's completely different. But so the first month was polite. Second month is less polite, a little bit more aggressive, and you might get a phone call. Third month, you're definitely going to get a much more aggressive message, and there's a high probability they're going to refer you to some sort of collection agent instead of dealing with the creditor in the first place.
Okay, so I got a couple of questions of that.
Yep.
First of all, roughly when do they refer you to a third-party collection agency?
So if you have no history of bad payments or missing payments, so this is your first time around, usually you've got to miss 3 payments before they're going to refer you elsewhere.
So, and it could be longer than that. It could be 4 months or 5 months or whatever it is.
And the logic's pretty simple. So if you're a bank that's lent people money and you're running all kinds of ads saying, I'm the helpful bank, call me if you've got trouble, and then you start harassing people for not paying, it's just counter to your marketing. And so you sublet all that work out to somebody else who can be the bad guy.
Because I want to be the friendly bank, and as soon as it looks like our reputation or our relationship is irreparable,
it's going south.
Get ready. Off you go. Go talk to somebody else.
Yep.
Okay, that makes sense. And it's probably also true that the employee at the collection agency gets paid less than the employee at the bank.
Significantly less.
Because they don't have all the benefits and all the other stuff and all the rest of it.
And there's no long-term relationship with any of these people anywhere. So
gotcha. Okay, so let's continue on with the story then. It's now been 3, 4, 5, 6, 7 months, whatever. And they've sent me to a collection agency. So I now have a third-party collection agency calling me.
Yep.
And I still don't pay because I don't have any money.
Right.
So what's the collection agency going to do?
Well, so first you need to know some stuff about the collection agency. So they're supposed to, either the collection agency or the creditor, send you some kind of written notice saying, hey, we've now hired these people to look after this for us. That almost never happens. And the reason you're supposed to do that is there's so many scam artists out there now. Why would you take a phone call or respond to an email if you don't know who the hell it's coming from and why they're contacting you? It's too easy for somebody to say, oh, yeah, you owe me $537 from 3 years ago, and now with interest and penalties, it's $2,500, and you write me a check and we'll be fine. Well, why would you even talk to that person?
So the law and we're talking about Ontario law here, but
Correct.
It's pretty
That's
much
where we live.
similar across Canada and wherever you're watching us from. When an account is assigned to a collection agency, they have to send you something in writing saying, we've been appointed by ABC Bank to collect.
This is why we are acting. We are real.
We are real. Okay.
And then they're supposed to limit the number of calls they make to, the law actually says they're not allowed to harass you. The problem is the law doesn't say what that means. And so almost all the collection agencies now use computers, or we call them demon dialers, and they just keep calling you through every hour if they have to. It doesn't count as a call if they don't talk to a human being. So the fact that Acme Finance called you at 8 o'clock this morning, and they're allowed to call anywhere from, I believe it's 7:30 in the morning to 10 o'clock at night, Monday to Saturday. Hours on Sunday are a little bit more restricted. But so let's say the demon dialer calls you at 8 a.m. Nobody answers it. 9, 10, 11, they just keep doing it. It bugs the living hell out of you, but they're not breaking the law.
Yeah, and I had somebody last week said to me, they called me 8 times yesterday.
Right.
I said, well, they didn't actually call you 8 times. The computer called you 8 times. You didn't pick up. But of course, you can see on your call display all these calls came in, and you're right. It's like every single hour they're calling me. So, okay, at what point then, if ever, is the collection agency going to sue you?
So the collection agency first, have they been hired to actually sue you? So some debts that go to collection agencies they're representing the bank or whomever the creditor was, and so they're doing whatever the policy is of the bank. And so the policy may be that they will threaten legal action. Whether or not they carry through is completely different. There are other times when collection agencies have actually purchased the debt. So this is usually an older debt. It's been outstanding for much longer, but they're more likely to sue on a purchased debt than they are on the bank's debt that's relatively new.
Yeah, and I agree with that. It almost never happens that a collection agency sues you on a debt where they are acting as a collection agent.
Correct.
And it's exactly what you described. I'm the bank. I hire ABC Collection Agency to collect on my behalf.
Yep.
It's still my debt. I still own it, which means that when the debt is collected, the money goes to the bank. Obviously, there's some kind of compensation for the collection agency.
Right.
They get, I don't know what the commission is.
And there are different collection agencies that provide different levels of service. So there are some that specialize in, we're the first one that the bank's going to use because they're a little more pleasant than the ones that are the last one the bank's going to use, which are likely the people that are going to sue you.
Now, you say the first one and the second one and so on. So what you're talking about is the first handoff.
Yep.
And so let's say 5 months I haven't paid. The bank sends it to ABC Collection Agency. They work me over for 3 or 4 months.
Right.
And they've sent me a letter and they've told me, and I still don't have any money. I still don't pay them.
And they get nowhere. And so they tell the bank, well, we're not acting on this one anymore. We're not getting anywhere.
So they send it back to the bank, and then the bank has a choice at that point, I guess.
Right. What are we going to do with this? And so they're either going to assign it to another collection agency, which you'll find is more aggressive, or they're going to let it sit and rot for a while, and then at some point they'll sell it.
Okay. So the second collection agency, would be perhaps more specializing in debts that are now a year old, a year and a half old, something like that. So how does the Limitations Act fit into all of this?
So the Limitations Act in Ontario basically says a company or creditor has 2 years to sue you from the last time you confirmed the existence of a debt. Now, confirmation of a debt for most people means you made a payment. That's not actually what the law says. If they have a recording of you saying, yeah, I know I owe you the money, that's considered confirmation of the debt.
Yeah, and this is an area where
it's gray.
Yeah, there is no law here really.
Right.
The act, the Limitations Act of Ontario, and you can look it up, says that it's a short act. Yeah,
yep.
It's not hard to read. It says the 2 years start from the default or when the default was knowable or when you would have been in a position to take action as a result of the default.
There you go.
What? What exactly does that mean? So that's been interpreted many different ways. So, okay, I made a payment yesterday. Clearly,
You must believe you owe the money
exactly.
because you made a payment.
I'm not in default yet, although maybe I am in default because I was supposed to pay $100, but I only paid $50. I don't know. Does that count?
Well, and you were supposed to pay the $100 6 months ago.
Right. So, but the general interpretation is, okay, the clock definitely starts from when you last made a payment.
Correct.
Although there's certainly case law that says, no, it starts from when you default. So there's a case with Capital One where they said, we don't start suing people till 6 months after they've made their payments,
right?
Their last payment, which is what you kind of just said. Okay, so that's when the clock starts ticking. So why is this 2-year clock, why does it matter? How does that impact what a collection agency is going to do?
Well, first, most people don't know about the Limitations Act, so maybe it doesn't have as much impact as we think. But if someone's going to threaten to sue you, and you know you haven't made a payment for the last couple of years, if you trot this act out, that'll stop them cold in their tracks because they're going to say, well, we'll go on to the next guy who doesn't know what the hell he's talking about.
Right. So when we get into the let's skip over to practical advice, then we'll come back.
We'll come back to this later.
You don't have the script in front of you, so we can go wherever we want.
Right.
So I haven't made a payment in 3 years. Maybe I haven't made a payment since before 2020.
Maybe you got an old cable or cell phone account
from 20 years
those are the
ago.
worst ones.
They are the worst. And so they call me up and they say, we're going to take you to court. We're going to sue you.
Right.
So you could say, well, this debt is like 4 years old.
Right.
So go ahead and sue me.
Yeah. Pursuant to the Limitations Act, I don't think you guys have a leg to stand on, and odds are they'll pick on somebody else.
Right, because collection agencies don't sue you anyways.
Right.
So to sue somebody who's got an obviously old debt. Now, they can still sue you.
Right. So the Limitations Act provides you with a defense in court. So the step that people miss here is that if they do sue you, the only way the court knows that the Limitations Act should apply is if you appear in court and tell the court. If you don't mention anything, you don't respond, the judge will just give them a default judgment, and now it's a real debt.
Yeah, so it's not as simple as, it's over 2 years old, I can ignore it.
You got to deal with it still.
Right, and so you deal with it by, as you said, saying to the collector, no way, it's too old, and if they still decide to sue you, then, well, you got to show up in court and say to the judge, look at my credit report, last activity was 4 years ago. Now, you made a distinction between a collection agency that's collecting and a debt buyer.
Right.
And so a debt buyer is exactly what it sounds like. So the bank has all these debts from, 3 years ago.
Yeah. Well, we started out with Canadian Tire. We know that every, is it 6 months or 9 months, they basically flush it.
Well, I think they have a forward flow deal now, but we won't
get too complicated.
We won't get into that. But yeah, there are many lenders will have a process where, okay, once a debt gets to this age, we've tried our own people, we've tried the collection agency, it doesn't look like we're going to collect it, we're going to sell it to a debt buyer.
And they sell it for pennies on the dollar.
Very low number. Maybe it's 1 cent, 2 cents. We don't know. They don't show us the deals. So why would Canadian Tire in this example or any other, all the banks do it.
Yep.
So we're not picking on anyone here. Why would someone sell a debt?
Well, you've already given up based on your own in-house procedures of recovering the money. I'm going to get something.
It's free money.
That's it. Make it go away.
And I guess it also crystallizes my loss.
Yep.
Because now I can, for tax purposes, write it off. Okay. So why would a debt buyer buy a debt that obviously nobody's been able to collect?
Well, so let's say you owe somebody $100 and they're able to buy that debt for $1. And so all they've got to do is convince you to pay them $10 or $15 and they're ahead of the game. And so it's a question of how many of those $100 debts are they going to be able to recover something from? And it's just, you do the math.
Well, and if one of those people does pay the $100,
well, then you've just justified buying the other 99.
The other 99, right. And all of these debt buyers, and you and I deal with them all the time. I've met many of them. They're very sophisticated. Like, they're not stupid.
Right.
They've got math and computers and algorithms.
Well, this is a specialized niche that they've found to basically get a very high rate of return on the debts that actually get repaid.
Right. And so they can go through a list and go, okay, well, these are the people we've got a better chance of collecting from. We've got different collection tactics that we can use, techniques and so on. So they've done the math. We know we can collect it. So, okay. So, and that's why a debt buyer potentially would sue you.
They might. Yep.
Because they're getting all the money. It does not make sense for a collection agency who's getting a 20% commission, which might end up being $100, to spend $500 on a lawsuit.
And unless the bank is going to guarantee all the legal expenses, a collection agency is never going to do it because they'll lose.
Right. Now, of course, this whole issue with the Limitations Act is a whole another story, which, I don't know, we've done some shows on it, and I'm sure we'll be revisiting it. Okay, so they threatened to sue me.
Mm-hmm.
How do I know if they're actually suing me?
All right. So there are two levels of courts in Ontario. Most of the other provinces, the same thing. There's the Superior Court of Justice, and then there's Small Claims Court. So either one of those could be used to sue you. If your debt is, I believe the threshold is $30,000 for small claims now.
Yeah, it's $35,000. It's gone up.
So if your debt is less than that amount of money, they can basically file the documents with Small Claims Court. The Small Claims Court will send you a notice saying that an action has been started against you. So you know that it's real because it's coming from the court. It's got, it's legal forms, and it's got a court registration number on it. And there's an expiry date. You've got to do certain things within a certain amount of time.
And that's the key point. There's a court number on it.
Right.
64-283 or whatever it is. And if you want to find out if it's legit, you can call the court.
Yep.
Because it'll say at the bottom, it's in the court of Milton.
All the contact information for the court's on it because the court sent it to you.
Right. So you can contact the court and say, hey, is this legit?
Yep.
It's in our list. Okay, now I know it's legit. There was a big scam a few years ago, and I saw it a little bit a couple of months ago with the fake statement of claims.
Well, and the Law Society, and I guess whomever else regulates this, made it illegal for collector agents, even lawyers or paralegals, to send out these
fake
statement of claims without actually processing them through the court. So they would send you a letter saying, we're going to take you to court. This is what it looks like. But if you don't read the cover letter, all you see is this legal document. And you go, hey, shit, I'm being sued.
So it's you definitely want to confirm that it's real. So, okay, so back to the process then.
Okay.
The collection agency calls and sends letters. If they are going to sue you, and maybe this isn't a collection agency, maybe this is the actual creditor,
right?
They have to serve you with the statement of claim.
So again, with small claims, they just have to mail it to the last address of record. With anything going through the Superior Court of Justice, you do have to be served, which means the documents have to be signed for by an adult living at the address that they have a record.
And so I guess I could just never answer my door. And
that's a strategy that some people use. Eventually, that will... there are ways that a creditor can get around that if they decide that it's worth doing.
Yeah, basically they go to court and they say, Judge, the guy doesn't answer his door, but we know he lives there. Here's proof that he lives there. Here's proof that he works there. We've called. We've done all this.
Right.
And the judge is, okay, here you go. So it actually gets to court.
Right.
Then what happens?
Well, so in court, first, once you've been served, you've got to tell the court, are you going to defend against this action? And so if you're going to defend, that means you're going to fill out a form and pay a fee so they'll actually schedule a hearing. Small claims court, they usually do some sort of arbitration or mediation before they'll actually schedule a hearing. For the Superior Court of Justice, it'll probably go to a hearing first, and then they'll decide how it's going to proceed after that. But again, there are forms that you have to file, there are fees that you have to pay. If you don't do those things and you don't do them within the deadlines, then the creditor, the person suing you, will get a default judgment against you. You won't get any more notices from the court. If you didn't respond to the first one, they get a default. The creditor will then apply for a writ of execution, writ of seizure. It's the same basic document. But the court won't tell you that application's been filed if you didn't file a defense in the first place.
And filing a defense is generally a fairly simple matter.
It is.
It is one piece of paper, and you say, I don't owe the money.
Yeah, with small claims court, it's very simple. With the Superior Court of Justice, actually, there's proper format you got to file. And your best bet is that you probably need a lawyer.
Yeah, and if it's Superior Court, you're probably being sued for 50 or 100 grand or more or whatever, so maybe it's worth it. So, okay, should I respond to the lawsuit or just ignore it then? How do I make that decision?
Well, it'll depend on each person's unique circumstances. So, for example, let's say you're on fixed income, you're a pensioner. Well, do you care if they get a judgment against you? In Ontario, you can't garnish somebody's pension, so you're probably safe. Now, let's say you're on a disability or some sort of social assistance. Well, again, do you care if they get a judgment against you? They can't access or take that money away from you. If you know you owe the money, then is there an argument for not bothering with the defense? I guess it depends on what your plan is to repay the money. Because if you don't offer a defense, and the judge says, okay, there's a default judgment, then they issue this writ of execution or seizure, they have the right to try to garnish you. Again, if you're not working, garnish you what? Or if you're self-employed, garnish you what?
Right. So I think you got to think it through to the next step.
Right.
So it's not getting sued that's the problem.
Mm-hmm.
And it's not even getting a judgment against you that's the problem.
It's when they enforce the judgment.
What do they do to enforce it? And if the answer is, well, yeah, I've been working at the same company for 20 years. Everyone knows where I'm working.
Yeah.
Okay, it's not going to be that hard to garnish your wages then. But if I've just started a new job and they don't know where I'm working,
right,
or I'm on a pension, I'm unemployed, I'm on disability, I'm retired, whatever, okay, how are you going to garnish your wages that I don't have?
Right.
So I think in all of these cases, you got to think through the scenarios, and we'll talk about that in a minute.
Something to remember in Ontario, there's no statute of limitations on judgments. So if they get a judgment, it doesn't just go away.
Yeah, it's pretty much there forever.
Right.
I mean, it's
until it's dealt with.
It's a little more nuanced than that, but basically just assume it's there forever. Now, we've been talking about unsecured debts, credit cards, bank loans, payday loans, whatever. What about secured creditors? I don't pay my car loan.
So secured creditors are creditors that have lent you money and they've attached some sort of charge or lien on a specific thing that if you don't pay, they can take it. So car loans are a great example, or a car lease. Basically, if you don't make the payments, they've got a legal right to come and take the car.
And they can still sue me after that.
And so there are a couple of ways they can. In Ontario, most commonly, yes, they'll take the car. They'll serve you with notice saying, this is what you owe us. If you don't pay us by such and such a date, we're going to sell the car at auction, and then we're going to ask you for the rest of it. If they've repossessed your car, you probably didn't have the money to pay it, so that letter doesn't serve much purpose except to put you on formal notice what's going to happen. They're then going to send you a letter after the car's sold at auction saying, this is what you still owe us. And then when you don't pay them for that, it's the same as before. It's now an unsecured debt. They've got to decide, are they going to sue you?
And it would be the same if I don't pay my house mortgage.
Mortgages are more complicated, but it's the same sort of idea.
Eventually, they take your house, they sell it.
Right.
If there's a shortfall that isn't covered by, well, if there's a shortfall, somebody's coming after you for it.
Correct, eventually.
And that's not a thing we've seen in Ontario for the last 20 years because house prices have always gone up, but might be something we see in 2026 and so on. So, okay, I want to throw 3 special situations at you.
All right.
And you tell me if any of this is different than what we just talked about. Situation number 1, CRA.
So the government doesn't really need to sue you. That's not true. If they're going to sue you, they do it in tax court, and then they just sign a form saying we've sued you. And so they send out then something known as a demand or requirement to pay. It has the same effect as a judgment. It goes to your employer. The employer is obligated to start garnishing your pay at whatever the order says they're supposed to do.
So if I haven't paid my taxes for 5 years, they don't have to go to court.
Right.
They can just send something to my employer and start taking my paycheck.
They do it internally. And what's worse, if you haven't filed your taxes in those 5 years, they can just arbitrarily assess you. And when they do that, they obviously always err on the side that's in favor of them. So you think your taxes might be $5,000 owing, they'll assess it so that you owe them $15,000.
Yep.
And they do that to get your damned attention.
Yeah, and in my experience, the most likely scenario where they're going to issue a requirement to pay and garnish your wages is when you haven't filed your taxes.
Right.
It happens far less when you filed them.
Yeah. Because
you're right, they're trying to get your attention. We don't know how much you owe us.
Well, and that's right. If you're filing your taxes every year and not paying, there are things they eventually will get around to doing, but they're much more aggressive when they have no idea what the hell's going on.
Right. And so all this stuff we were talking about, Superior Court, it doesn't matter. It's right. CRA, they can do whatever they want. And they can also freeze bank accounts.
Well, and you know what's really interesting about CRA, it's not illegal to not pay your taxes. It is illegal to not file your taxes. So it's a whole different kettle of fish. Now, again, for most people, they get around it by simply saying, okay, you didn't file, so we think in 2023 you owe us $50,000. And they don't give a crap what you actually owed them. That's what you now owe them.
And since you didn't file your taxes, you can't prove that you didn't owe them that money.
Right.
So... Okay, so CRA,
it's very special.
Totally special situation. They got lots of powers.
Right.
What about support payments, child support, spousal support?
Yep. So the Family Responsibility Office, there'll be people that know what that is that are worried about support. There really is no way to get out of a support order except to go back to family court and have it changed. And so if you're not making the required payments that the order says you're supposed to make, Family Responsibility Office can simply reach out and garnish your wages. They can I believe they can put a demand through a bank account, but I don't know that they don't use that very often.
No, typically it's a wage garnishment. So if you have and again, we're talking about a court-ordered support here.
Right.
The court has said you have to pay this much. You're not paying it. They've already been to court.
Right. Well, and the tools they use is obviously they garnish your wages. They suspend your driver's license. There's lots of tools that the Family Responsibility Office has.
Tax refunds. They can take tax refunds. Yep. So they don't need to go through the normal process. So The third situation I hear is old debts. I think we've already talked about that.
Right.
And the short answer on that is, okay, if a collector is collecting for a debt that is well over 2 years since you've last made a payment, last had any activity on it, then you can say, hey, go ahead and sue me.
Right.
Because it's too old. Now, it's still on your credit report. It's still messing everything up.
Yeah, I mean, there's been a lot of changes in the laws in the last couple of years about old debts and how they're being dealt with, and it's all screwed up right now. None of it is being dealt with properly.
It's a huge mess. So, okay, so let's go to the practical advice section here. So
pay your bills when you can.
There you go. Thank you very much for coming out.
Show's
Please
over.
Like and subscribe, and obviously everybody watching is going, yeah, I know, I'd like to, but I lost my job, I got sick, something happened, so that's why I'm behind. And in some cases, it's not even my fault. I co-signed for my brother or my ex or somebody, and everything was going great. They had a good job. I helped them out. Now they're not paying, and I'm stuck with it. What am I supposed to do?
Well, you want another scenario, identity theft.
Yeah,
you didn't even know you had the damn debt because you never applied for it,
and now I'm on the hook for it. So okay, so practical advice then: you are getting a collection call. What's your thought process?
So you've got to decide: do you want to try and deal with these people at all? There's almost never a good reason to send money to a collection agency. There's almost never a good reason to even talk to the bastards because you don't know that they're going to tell you anything true. They're just going to try and scare you. And if you do give them money, they're going to call you tomorrow and ask for more.
Yeah, and I guess it depends. What are we talking about here? If it's a debt that's 6 months old, it's just been turned over to the collection agency. I was unemployed. Now I'm working. Yes, I can pay it.
Right.
Then pay it.
Right.
And you can certainly make an arrangement with the collection agency. Okay, here's what I can do. Now, they're going to want all the money today.
They are.
Because they want their commission right away. But if you say, look, I can get this paid off over the next 2 or 3 months, I can start sending you money. So long as you got some paperwork from the collection agency that proves they are legitimately entitled to collect it, then make a deal with them. If they are not able to, I mean, if it's a debt that's really old, then I agree. It's like, forget it.
All that sounds good. I don't think it's going to work.
Because they're going to keep calling, and
they are, and they're going to take their fee off, and then you're still going to owe more money on top of that, and it's difficult to deal with a collection agency because that's just the nature
and I
of the
think
beast.
Again it makes sense if it's a relatively manageable amount, and if you can get it in writing. Yes, if you pay this much, that's full and final settlement, and if that's the only debt you're dealing with, great.
Right.
Most people, when it's in collections, they've got a few other things. So so if I get court paperwork, what should I do?
You definitely want to read it, and you've got to decide, are you going to respond? The mistake that most people make is that they don't respond, they just ignore it, and then all those default things we talked about earlier kick in.
And what if it's already gone to court, they've already got a judgment, and now there's garnishment papers sitting at my employer's?
Okay, so now you're at the point where I guess you could hire a lawyer and go and ask to have the order varied, but it gets expensive because you didn't deal with it in the first place. The practical solution, if you've got a wage garnishee or anything like that, CRA notices, contact a licensed insolvency trustee because maybe it's time to do a consumer proposal.
And obviously we're biased here, but we think if you're getting collection calls, you should talk to a licensed insolvency trustee about that too.
Right.
Because we can at least go through everything. And
it's at what point do you need to talk to somebody to get some independent advice? The longer you leave it, the fewer options you're going to have.
Yeah, and what's the downside to talking to us now? Like, it doesn't cost you anything.
Right.
So we might say, oh, you got a $200 cell phone bill, just pay it.
Right.
You've got 16 different debts in collection. Okay, different story. Or you've got something like CRA where you're not making deals with them. Right. They want their money. So I think what we've tried to do in this episode is walk you through what can happen. In any case, unless you legitimately don't owe the debt or you can pay it off pretty quickly, if you're getting calls from collection agencies or you're getting judgments, garnishment orders, then it's probably a serious enough situation that you got to deal with it.
Correct.
And I agree with you. The sooner you deal with it, the better.
Debt problems don't go away by themselves.
That's not how interest works. It always gets worse, not better. So there you go. If you're having these issues, talk to a licensed insolvency trustee. By law, our initial consultations are free. We're not allowed to start charging you anything until you've signed the paperwork.
And that's an important point. If it's getting difficult on the internet to figure out who the hell you're talking to. If when you call one of these people that say they can help you with their debts, the first thing they do is ask you for a fee, you're probably not talking to a trustee.
Well, you're not. You're getting scammed. Right. So there are no upfront fees when you talk to a licensed insolvency trustee. So there you go. I will put links into the show notes to the stuff we've talked about. And again, if you're having these issues, contact a licensed insolvency trustee. We will walk you through it. That is our show for today. As I say every week, like, subscribe, notification, you know the whole routine.
If you want to sponsor us, send us
If you
some
want
money.
to sponsor us, then just make a check payable to Ted Michalos, Michalos, and we'll see if we can get you in. We will have a brand new show, probably with no sponsors again, next week. What was this? This was show number 560. So
And we don't have any yet.
Still no sponsors yet, probably next week. That is our show for today. Thanks for listening and watching. Until next week, I'm Doug Hoyes. That was Debt Free in 30.